All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. Good afternoon. We are here for oral argument in CV18-0072 Shepard versus COSTCO. We record these proceedings, so please give us your name and the name of your client as you approach the podium. And as you know, each side has 20 minutes for your argument, and you are in charge of keeping track of your own time using the clock in front of you. Please keep in mind, we have read the briefs, we have reviewed the record, we have conferenced the case among the panel. And with that, you may proceed.
Thank you, and may it please the court. My name is Joshua Carden, and I represent the appellant, the plaintiff below, Greg Shepard. We've asked that the court reverse the trial court primarily for two reasons. One is that there is no barrier in Arizona for a plaintiff to use a statute to inform a duty of care in negligence actions. And second, because we believe that the complaint below, the second amended complaint, is the one that was before the trial court, alleged enough stuff to overcome the good faith presumption at the Rule 12 stage.
If we could start talking about the negligence claim.
Absolutely.
I think you've identified that because of the way the immunity statute would work, you have to not only establish a breach of the standard of care, but also some version of bad faith. Isn't that right?
I was actually contemplating that this morning, Judge Thompson. The thing that has troubled me about that aspect of it is the statute simply says that a good faith disclosure made under this article, the entire schema for medical records, is protected. And then I have to show by clear and convincing evidence that it was not in good faith. I didn't put the magic words bad faith in my complaint. I offered to do that to the trial court, but that to me is the seminal question, is if I have to overcome that presumption, then I have to prove something. I have to prove it wasn't in good faith. If the court finds that bad faith is automatically the opposite of good faith, then yes, I guess I have to prove bad faith. But that's where we get into the nuances of the definitions, and as we've, frankly, both sides have briefed, bad faith kind of has one set of criteria, and then someone who is acting in good faith has a slightly different set of criteria. Is it mere carelessness? No. That's I think both sides would agree, is looking at the statutory, the cases that have interpreted the statute. But I haven't alleged just mere carelessness. I've alleged that not only were there financial incentives to try to get this prescription filled, that there was objection made by Mr. Shepard to this prescription, and that once that objection is made, in this case it was made more than once, whether it's under HIPAA or the medical records privilege, I think that refusing to honor that objection becomes an indicia of a failure to act in good faith or bad faith if the court finds that those are simply two sides of the same faith coin. And that's been the battle of the mostly out-of-state precedent in this case. We have alleged that by his objections, by the pharmacist saying, "I'll cancel the, I'll take care of that. Thanks for letting us know," that's enough to show that the pharmacist, on multiple occasions now, failed to act in good faith, which overcomes the presumption.
And of course, I just worth keeping in mind that, like you said, what you have to show, I'm not sure how much you have to show at this stage. You have to state it.
Correct. And that was my frustration with the ruling, was not a dismissal without prejudice to replead or more fully develop the relevant allegations. This is a 12b6 motion that Judge Anderson was saying there is no way you can ever overcome, no matter what you allege. There's no way under these facts that you could ever get to a showing that COSTCO failed to meet its good faith presumption. And I think that's a very dangerous precedent to set, because that means what could anybody show if we're going to cut it off at the pleading stage to show that a pharmacist has actually breached their duty? I mean, if he'd put it on a billboard, is that going to be, well, I thought I had permission to put it on a billboard? Is it subjective from the pharmacist standpoint? Oh, well, I thought it was okay. He authorized his ex-wife to pick up the other prescription, so it must be okay in those circumstances. And that's where we get into that decision on good faith from the trial court basically permeated the rest of the ruling. All of the negligence causes of action, and I will confess that most of the time I'm dealing with employment cases, and so finding some of these more archaic torts was revelatory for me to see what they involve and what they don't. And I believe I even said that to Judge Anderson. I understand that in picking from the menu of tort actions that one or more of these might fall by the wayside, but just the straightforward duty breach cause harm, and COSTCO's position being that there is no way you can look in the aggregate to all of these sources for what might govern a pharmacist's conduct and somehow construe those into a duty of care that COSTCO violated. We're beyond good faith immunity at that point. That's what can a pharmacist do ever?
Assuming you've stated enough to allege a cause of action, a duty rather than a breach, what are the damages that you've alleged, compensatory damages you've alleged? That was not entirely clear to me.
The full range of compensatory damages, Your Honor, and I just had to put these in some jury instructions, would include. I can't remember if it's. I think it's 8. That may be an employment law one, but under the Rajis, it's loss of enjoyment of life, it's anxiety, it's any of the standard tort damages that come about from an injury. So it doesn't have to be a physical injury. It doesn't have to be he lost wages or something like that. It can be the emotional side of damages.
Is your client alleging that his purported reconciliation with his wife affected by this? Yes, he is alleging that, and with good reason. Again, at the pleading stage, of course, we're presuming everything to be true, but that is precisely what happened in the process of that. And obviously the language it used at the time was a little more colorful. It is in the pleadings below. And I always hesitate before sharing explicit details like that, but I wanted to make it clear for the trial court that seemed to be the reason. It didn't seem to turn on anything else based on the statements made by the ex-wife, which goes right into, was this an intrusion upon seclusion? Was this public disclosure of private facts? COSTCO has argued again that if it's not widely publicized, then it must not be public disclosure of private facts. We've offered statements. We've offered quotes from the restatement of torts that say it doesn't have to be, all the public. It can be a particularized public, which in this case would be exactly what happened. It was his ex-wife, whom he was trying to reconcile with. It was his children. It was close friends. All of these having a significant impact on him emotionally and mentally, and that really is the crux of the damages in this case. It's not a physical injury. It's certainly a mental and an emotional one. The precedent in Arizona on using federal statute like HIPAA is certainly thin. I don't think there's been any disagreement about that. Well, there is some disagreement between COSTCO's counsel and myself as to how to read the Skinner case, the federal case there. I've argued that the district judge very carefully did not decide that the Arizona immunity statute could not serve as the basis for a negligence cause of action, and said that the district court said it was going to allow the plaintiff the opportunity to amend the complaint, or at least ask to amend the complaint to say that was going to inform the negligence cause of action. I had provided a cite to the Gomez case where, and I think I misspoke and said Judge Teelborg in my brief, is actually Judge Tucci, had written that
as a throwaway example, almost, is saying that, well, sure, here's how you can do that. You can't bring a private right of action here, but you can use it to inform a duty of care, for example, such as using HIPAA to supply the duty of care for a state law negligent claim. And then the other point I tried to make was that the Webb versus, I believe, Smart Documents in the Ninth Circuit, the holding in that case was not quite as broad as what COSTCO tried to argue. Webb was being very careful, the Ninth Circuit was being very careful as to what it would assume jurisdiction over. And of course, if HIPAA allowed a federal private right of action, there's no problem. You've got federal question jurisdiction, and the court was making a clear distinction between federal question jurisdiction, saying it's not a private right of action, you can't get to federal court that way, but you could get there potentially through diversity jurisdiction if the other requirements of diversity jurisdiction are met. The out-of-circuit case law, and I should have done this sooner, and I apologize to the court. I tried to provide a brief update. The case law has continued to develop in this area. There's no silver bullet, but there are a smattering of decisions that have come out just in the last several months of this year that have gone both ways still. Virginia said, no, we're not going to allow that because there was never an underlying common law duty to begin with. And then some of the other courts have decided the opposite and said, much like the Connecticut Supreme Court did, when you have duties that are clarified by statute, that is a perfectly appropriate chance to either allow them to inform the duty of care in a straightforward negligence action, or to allow them to directly inform actually establish the duty and breach elements in a negligence per se action. I don't really have anything further in terms of an opening here. If there are any other questions from the panel, I'd be happy to answer those. If there are any other things I can answer, if not, I'll sit down and save some time for rebuttal.
Well, maybe just touch on the question of punitive damages. Since,
very good.
Again, if we start with the negligence claim and you need to show some form of bad faith to avoid immunity, you need something further, do you not, for punitive?
I would agree with that, Judge Thompson. And what I have there again is, and this is always difficult when you're talking about a multi-headed hydra, so to speak. We have multiple actors in this case, and I'm saying in the aggregate, and including my allegation that there's a strong financial incentive for pharmacists to not cancel prescriptions, I think that there's enough there to send that question to the jury. I mean, even in the Thorpe case, which I actually got to litigate, the judge said there's quite a bit of stuff there. It was enough to say reasonable minds could differ as to whether a jury might find this particular act was sufficiently outrageous in the community, and coupled with, was this an act done with reckless disregard of the rights of others? It was certainly a poor decision in the moment. I would argue that's enough of a theory to proceed forward and develop, and frankly, it may very well turn on just how strong that incentive is to not cancel prescriptions, or how specific the duties are and customs within the industry to see how far outside the lines COSTCO colored in this case. I'm not saying I'm a lock to get punitive damages in this case. I'm saying I should be allowed to at least engage in some discovery to find out how bad it was and revisit this, perhaps on summary judgment if it comes to that. Thank you.
Good afternoon. My name is Karen Stafford on behalf of COSTCO. I want to start off by addressing Judge Thompson's question, which is, do we have a negligence claim at all if there is not a proper showing of bad faith alleged in the complaint to overcome the presumption of good faith? And that is the seminal question, because the immunity provided by the statute requires that there be allegations in the complaint of sufficient bad faith conduct to overcome a presumption of good faith. And while the appellant's counsel talks about he should be entitled to discovery of that, immunity is something that must be decided at the outset. A defendant shouldn't have to withstand suit at all if it is immune from claim. And here, the presumption is that the disclosure was in good faith. And in fact, the facts as they are alleged are consistent with that. There are no facts alleged of bad faith conduct.
Excuse me, counsel, doesn't plaintiff allege here that COSTCO's refusal to cancel the prescription twice should be coupled with the allegation of a financial incentive on the part of the pharmacy employee, and that those taken together establish sufficient facts of bad faith?
Well, I think that's the argument, but I think that argument fails for a couple of reasons. First of all, the allegation is that COSTCO failed to effectuate a cancellation. And then it presented appellant's ex-wife with a prescription for medication, which she was authorized to pick up, and then a second prescription for medication, which was supposedly meant to be canceled. And that's the extent of it. This is a typical pharmacy transaction.
All right, doesn't he allege that he tried to cancel? He canceled it twice, and was assured by COSTCO that it was in fact canceled.
Certainly. So if we take all the allegations as true, which of course we stipulated, and we submitted proposed findings of facts and conclusions of law to the judge, and stipulated that all the allegations that are the factual allegations are true for the purposes of the motion, of course. And even if we accept that it's true that on 2 occasions COSTCO failed to effectuate a cancellation, that does not rise to the level of bad faith that's been defined by Arizona courts. So the Ramirez case, which was cited in our brief, talks about a similar statutory immunity. It's an immunity provided to a healthcare provider for the good faith conduct that's done in compliance with this particular act, which was the Uniform Anatomical Gift Act. That the Ramirez case said that the bad faith allegations to overcome the good faith presumption in that statutory immunity has to be, quote, honest. I'm sorry, the good faith presumption is, quote, honest belief, the absence of malice, and the absence of a design to defraud or seek an unconscionable advantage. It was citing Black's dictionary. The case went on to say, all acts and omissions are presumed to be in good faith unless the acts or omissions are done with an intent to maliciously cause injury. That's what's missing here. At most, we have a negligent failure to effectuate a cancellation and then presenting a prescription to someone who is authorized to pick up medication. That's the extent of this transaction, which is a typical pharmacy transaction.
How does the allegation of financial benefit factor into that analysis?
Okay. There is one allegation, and it's kind of a very bare allegation that there's a financial incentive out there for COSTCO Pharmacy to not cancel prescriptions or not effectuate cancellations for somehow a financial gain. But this is not like some other product that is sold in stores. There are no prescriptions filled unless they are ordered from a doctor. This is an allegation that is not a reasonable inference that the court has to accept as true. It would require the court to infer or make a reasonable inference that COSTCO somehow benefits financially. When physicians call in prescriptions, COSTCO fills those prescriptions, and then when there's a cancellation, it would purposely not effectuate a cancellation in the hope that it could force an unwanted medication on a customer when for an ailment that they may no longer have. It's like assuming that someone ordered, was prescribed cold medicine, but maybe their cold cleared up and they canceled it and came in for something else, that somehow COSTCO would benefit financially by trying to get a customer to buy medicine they don't need. This is not a reasonable inference.
Well, I mean, if the customer buys the medication regardless of whether or not they need it, COSTCO did financially benefit. They sold something that the doctor's office or the client, either one, had said no longer needed to be available, but COSTCO made it available. And if they are successful in that transaction, COSTCO does receive a financial benefit. That's how that works, right?
I see the connect. I mean, I see what you're saying, that if a sale does go through, I guess COSTCO would have a financial benefit. But the idea is that it requires the court to make such a leap, such a presumption that there is some sort of scheme in place where COSTCO's hoping that prescriptions just get canceled, but that customers will be persuaded into buying them anyway. It's such a unique product. There's, if you want to compare it to a product that you sell, an impulse buy, something at the register, and there's an incentive to try to sell these products and try to convince consumers that they need them or want them. That would be more of a reasonable inference than to try to push prescription medication, which can only be ordered by a physician. It's not as if COSTCO is waiting to try to push drugs on customers. The prescriptions were ordered. So it's probably there are probably very rare cases where we have an ordered prescription by a physician and then followed by a cancellation for whatever reason, and then the customer then choosing to buy it anyway because of COSTCO's, purported scheme to, profit off of a canceled medication. This one allegation in the complaint is, first of all, it doesn't go that far. It doesn't allege any of those facts. It doesn't allege that there is this idea that, COSTCO would persuade customers who don't need medication to simply buy it anyway. It's just a bare bones allegation that there's a financial incentive without any other facts really to support that. And it's our position that that is an inference that is not a reasonable one to draw. And the court is not required to assume unreasonable inferences, conclusions of law without factual support, those types of things to rule on a motion to dismiss. Coupled with all of the other conduct, which, like I said, at most is mere negligence, which is exactly what the immunity statute is intended to protect, is the good faith, potentially erroneous disclosure. Here, I would argue there was no erroneous disclosure. It was fully contemplated under both state and federal law. HIPAA regulations allow the disclosure of prescription information without consent to a close friend or family member. Here, there was consent to pick up medication. The plaintiff wants to argue that somehow that consent was very narrow, but his complaint only alleges that the consent was given for COSTCO to provide appellant's ex-wife with his regular medication. It's not, the allegation is not that there was some very specific narrow consent. There is no basis to assume that COSTCO would know what is appellant's regular medication and what is not appellant's regular medication. It's very possible the medication at issue in this case could have been his regular medication. The point is that the facts don't allege a violation of the law, but even if they did, and this was really articulated in the Ramirez case, even if a mistake was made, an error, a disclosure that shouldn't have been made, the idea that is what the immunity statute is for. In the Ramirez case, the plaintiff made the same argument that, well, if the disclosure is not contemplated by the law, then the immunity doesn't apply. And the Ramirez case said very clearly that would completely eliminate the purpose of immunity. It's meant to apply when there is a good faith, potentially negligent or erroneous disclosure. In terms of the negligence, putting aside the requirement to allege bad faith, which the allegations here just do not amount to bad faith. But putting that aside, can there be a negligence claim here? The argument is that that the standard of care that should be applied is informed by the HIPAA regulations. The problem is HIPAA doesn't provide a private right of action. And we have lots of cases in lots of different states. There are many cases in many states saying because of that, you can't sue for negligence and then point to HIPAA regulations to inform the standard of care. I understand that plaintiff has cited cases in other states that say the opposite. The reason those cases don't apply here is because we have a statute in place that precludes a negligence claim for this type of disclosure, provides immunity for it. So the Arizona legislature has already spoken on what kind of claims can be brought against a pharmacy for disclosure of prescription information. And that is those claims that rise to the level of bad faith, but not mere negligence claims. plaintiff is saying he's left without any redress, but there is a whole statutory scheme, or excuse me, regulatory scheme in place under HIPAA. Appellant could have filed a complaint with the, Secretary of Health and Human Services. There is a administrative procedure that would have taken place. There's monetary civil penalties that are available, and that claim is meant to be brought there and not under a common law negligence claim. The Skinner Court that was cited by both of us in our briefs stands for that proposition and dismissed the same case, basically, disclosure of prescription information. In that case, I would argue that the negligent disclosure was even more egregious. In the Skinner case, there was this repeated faxing of private prescription information to unidentified third parties by error, I assume, and it just continued and over again. The federal court, the Arizona federal court, still said that this did not confer a negligence claim for plaintiff because the plaintiff was relying on HIPAA regulations, the violation of HIPAA to inform the standard of care. Because there's no private right of action, that can't happen. Appellant also says that there's not a lot of case law in Arizona where courts talk about pointing to federal statutes to inform a standard of care. I did cite some cases in our briefs, the Rodriguez case, the Bard case. These are federal cases in Arizona that did dismiss negligence per se claims that are based on alleged violations of federal statutes. They're not HIPAA, but it's an example of when you have federal statutes that don't confer a private right of action. You can't circumvent that by trying to allege a common law negligence claim and point to those regulations to inform the standard of care. So our Arizona federal courts have dismissed similar claims pointing to similar federal statutes that also don't confer a private right of action. And I'm happy to talk more about, I can move on to the privacy torts, but if there's something in particular that I can answer in terms of the negligence claim or the immunity issue. Okay.
What about the claim for punitive damages? We don't have any special pleading requirements for punitives. The complaint does allege malice and oppression or reckless disregard. Why isn't that enough to get past the Rule 12 motion?
An allegation of malice or reckless disregard are simply legal conclusions. There aren't facts that are alleged to support a conclusion of malice or reckless disregard. And this really just harkens back to the idea that the facts as alleged, and assuming all of the facts to be true, we have at most a failure to effectuate a cancellation and a disclosure and a presentation of medication to a woman who was authorized to pick up medication. But there aren't any other facts that are alleged to support a legal conclusion of malice or reckless disregard or bad faith, or even this also applies to the intentional infliction of emotional distress claim. And I
think I just read an article in the Arizona Attorney, but we're not supposed to say something's objectionable because it's a legal conclusion.
Something is objectionable. I think that if there is, to rise to the level, to have a cognizable claim for punitive damages or for the bad faith conduct or for intentional infliction of emotional distress, it has to, the allegations have to allege facts that at least rise to that standard. They can't be inferred simply because of a bare legal conclusion that there was malice. There's no fact to support that.
Notice pleading just to alert you that your client may face a claim once that gets down to what the proof really is?
Well, I think the purpose of notice pleading is to put the defendant on notice of what conduct is alleged to have been done in malice. So to simply say COSTCO acted in malice, I think is insufficient because, again, it's simply a legal conclusion that this court doesn't have to presume is true, and it doesn't put defendant on notice of what was allegedly done in malice, because right now we have an allegation that twice the cancellation wasn't effectuated, and that's it. That's what this entire case is based on. So I think that the notice requirement or the notice pleading standard isn't met because defendant isn't put on notice of what was done in malice.
Is it almost impossible to get to the intent issue unless a plaintiff is allowed to conduct some discovery?
Well, I think that we have to start with the allegations. So if the allegation that there was intent or a dishonest motive or deceit, if the allegation existed, well, then certainly then the plaintiff would be allowed to then conduct discovery into those issues.
Circling back into this allegation of financial incentive, and I understand your point that it's one line in the complaint, and maybe in your view that's not sufficient, but I'm just trying to understand how a plaintiff could have that proof sufficient to beat back the Rule 12b6 motion.
Well, I think the opposite is actually true. So if there was a real theory of financial incentive, that could have been sufficiently alleged with actual facts to describe what that incentive might look like, or what could be discovered, what could be proven, what is the alleged scheme here. Right now we have one bare allegation that there's a financial incentive. So the idea is then if all we need to do is to state a cognizable claim is to guess that there might be some incentive out there, but I don't know what it is, but I'll throw it in the complaint.
But in this case, the trial court said, I can't imagine any facts out there that would allow you this claim to be sustained, so dismissed with prejudice. Under your approach, wouldn't the appropriate action be for the trial court to dismiss without prejudice or with leave to file an amended complaint alleging those specific facts?
Well, I disagree respectfully that that's what the court held. The court held that amendment wouldn't cure the flaws because alleging the magic words, as appellant's counsel has said, the bad faith or maliciousness or whatever it is, those legal conclusions don't get you there. What was missing are the factual allegations. And you don't amend complaints to create facts.
The plaintiff knows that COSTCO was told more than once that an individual did not want a prescription. Let's take this out of the current realm and say, what if it was some type of opioid, some type of painkiller, some type of regulated medication? And COSTCO is told repeatedly, I don't want this medication, I'm canceling this medication, and instead fills it and keeps offering it to an individual. So this is maybe a more serious, I guess, type of medication that they are repeatedly providing to a customer. Are you saying that there is no possible hypothetical circumstance in the background that would explain that type of error other than just oops, repeated oops? Isn't it possible that maybe somebody could draw the conclusion that there's a financial incentive here, because why else would you be so careless with prescription medication and attempting to give it to somebody who has repeatedly said they don't want it? So that carelessness might suggest that something else is going on in the background. Is it the plaintiff's responsibility to come up with hypothetical situations to get past 12b6 because they have not been given any discovery yet to determine what exactly is that financial motive that must be there, because why else would a pharmacy be that careless?
Well, I do think that the plaintiff does have to allege the facts necessary to support a conclusion. Now, whether they obviously don't have all the facts, but let me answer your question about your hypothetical, because I do want to point out that while medications can be, are serious, and of course nobody should be given medications that they shouldn't be taking, we have to remember here that a pharmacy is only filling medications that are ordered by a physician. And so if a customer chooses not to...
Are you saying the physician repeatedly ordered this medication over his patient's objection?
No, I'm sorry. I'm just addressing the scenario where...
I know, but here is a scenario where maybe the physician ordered it once, but thereafter the pharmacy was told repeatedly that it was not to cancel that order. So coming back to that, we only fill it when the physician orders it. Is not all that persuasive when there's been an intervening cancellation from that order?
Well, I guess that my response to that is that the allegation wasn't that there was some intervening, try to stop it from getting filled. The idea is that a prescription is ordered by a physician, it's filled. So then when a customer says, I no longer want that, then what COSTCO would then likely do is not present it to the person picking it up. But there's not an allegation here that there was some sort of interception between the time in which the physician ordered it and the time in which COSTCO filled it. And so a typical pharmacy...
That wasn't my point. My point was, so the doctor orders it, COSTCO fills it, there's a cancellation. another month goes by, and it's either filled again or was never reshelved, both of which are problematic from a pharmacy perspective. It's my understanding that pharmacies don't just hold on in perpetuity, filled prescriptions that are not picked up.
Well, that would be an allegation then that I think that would be a different scenario. It would be a different set of alleged facts to say that the prescription sat there for a month or it was reshelved and then refilled. And maybe I still think that doesn't get you there.
What other reasonable inference is there from this set of facts?
That it was shelved and refilled, or
how was it still available a month later if it wasn't either refilled or failed to be reshelved?
I don't think the allegation states that a month had passed. My understanding is that the prescription was ordered, and that a call was made to cancel it, and that cancellation, 2 calls, and that cancellation wasn't effectuated, and then appellant provided permission for his ex-wife to pick up his regular medication, which really, could be this particular medication. I understand that it wasn't, but I don't know that that's alleged that COSTCO should have known that. And then the appellant's ex-wife did in fact pick up the prescriptions. So the error here that's being alleged is the failure to effectuate a cancellation. Whether 2 phone calls and the failure to actually effectuate the cancellation rises to the level of bad faith, I would say the answer to that is no. And I would say that the Liska case also, here we have 2 cases that have interpreted this bad faith
Are they
requirement.
In your
Yes.
All right. Your time is up. We'll let your opposing counsel
I'm sorry.
speak to us. That's fine. I asked
Thank
questions,
you.
but perhaps you could clarify the timeline for us.
I would be happy to do that, Your Honor. In the proposed findings of fact that the court signed on below, Mr. Shepard was first presented with the erectile dysfunction medication on either January 4th or 5th. That's paragraph 6 of the order. He immediately said, he's there in person for this one, and he says, I don't want that, cancel that prescription. February 13th, 5 weeks later, he is getting his regular monthly prescription, and on the phone is told, oh, we've got that. Oh, and we have this other medication. He says, I didn't want that. I want it canceled. The next day, he hasn't had a chance to go pick up the medication yet, and this is paragraph 11. He asks if his ex-wife can pick up the medication he's expecting to get. In that phone call, there's no mention of, oh no, by the way, we still, from yesterday and from 5 weeks ago, have this other medication that you don't want. Do you want us to have her pick that up too? They don't even mention it, which is another fact. I think it's more of a sin of omission than commission in this case.
So when the doctor apparently phoned in the prescription initially in
Yes.
January, did he set it up as an auto refill?
That's not in the record. No, it's not in the record. But yeah, this was not the doctor's calling it in, along with the regular prescription every month. That is not my understanding. This was a one-time fill, which was exactly the point you were getting to, Judge Perkins, which is 5 weeks has gone by. I don't yet know exactly what the standard is for when you reshelve medication that hasn't been picked up, but 5 weeks seems a little on the outside. And that's not the only the only allegation here. Besides the financial incentive, it was the COSTCO employee made fun of him in the process. That was the sort of the little extra little bit to me that would justify the punitive damages. Going back to your question, Judge Thompson, is to say, that it's not just, it was an accident and we didn't fill it. It was a mocking filling, a mocking handing over to the ex-wife. Opposing counsel hit on briefly that under HIPAA you can get permission to disclose, and that's true. There is an informal permission that you can give, but the examples given in the statute and by the Health and Human Services are the pharmacy is allowed to infer that someone has been given that information when they show up and ask for it. Oh, I'm here to pick up X for Greg Shepard. that should suggest to the pharmacist that they have been given permission. Mr. Shepard's ex-wife would have never known to ask for this other medication absent COSTCO volunteering that information. That is not the kind of disclosure referenced. Opposing counsel brought up the Ramirez case. That is a case that was decided on summary judgment after discovery. On appeal, the appellate court simply affirmed the trial court's decision because there was ample opportunity to develop the full record in that case. And as to the immunity definition, the immunity statute in Ramirez and the one in this case are written very differently. The Ramirez immunity under the anatomical gift statute says good faith is presumed, and here's what you basically have to find to show that it wasn't good faith. You have to find malice. You have to find intent to cause injury. It adds words in the statute that are simply not present in ARS 12-2292. Our statute very specifically extends that good faith immunity when the disclosure has been made under that article or pursuant to applicable law. And I've argued repeatedly that that's not what happened here, that this was not an authorized disclosure, it wasn't made pursuant to any law, and therefore COSTCO does not get the benefit of good faith. COSTCO doesn't put its financial compensation schemes for pharmacies online anywhere. If they were, there would probably been some more detail in the complaint on this. Ethics rules forbid me to go ask the manager why this was handled in this way or what incentives they might have. I believe there was enough information available to me at the time to satisfy certainly Rule 11 to make that provision. I might find out that COSTCO is completely innocent and that it was purely an accident, and like I said, once we do that, then we'll have more information. But having my claims dismissed with prejudice without the chance to develop a record means that's all we have to bring before this court. And I would ask that this court reverse the trial court's decision and remand for further proceedings. Thank you very much.
Thank you. Thank you, counsel, for your arguments. We will take the...
I'm sorry, just very quickly, I wanted to address the idea that there was a supplemental citation of authority filed yesterday, and if the court were to consider those cases, I just wanted to ask for a chance to file briefing on those, since we haven't had a chance to brief those, if the court were to consider the cases that were brought to your attention yesterday.
I don't think we need any further briefing. Thank you. We'll take the matter under advisement.